Well, good afternoon, and thank you for joining us for today's Manulife Business Success Series webinar on privacy and employment law issues in the age of COVID. My name is Ian McLean, and I'm the President CEO of the Greater Kitchener-Waterloo Chamber of Commerce. Before we get started, I'd like to take a moment to acknowledge that we do live and work on the traditional territory of the Neutral, Anishinaabe, and Haudenosaunee peoples, as we seek a renewed relationship based on a foundation of mutual understanding and respect. Today's session would not be possible without the continued support of our sponsors and partners. And so a special thank you to our title sponsor for the Business Success Series, Manulife, our platinum sponsor of the series, the Immigration Partnership of Waterloo Region, and this month's presenting sponsor, Learners LLP. These organizations are committed to supporting our local economy and providing businesses with the resources and tools they need to thrive. Just before the session starts, I'd like to go over a few quick reminders. Please ensure that your microphone is muted throughout the presentation so we can reduce any background noise. If you have any questions that come up through the session, you can type them into the chat box in the control panel anytime. And if it's a tech-related issue, a representative of our team will get back to you right away and get that resolved for you. I'll gather the questions for the presenters today and do our best to make sure those questions get asked when we have our fireside chat after the presentation. All attendees will be sent a recording of today's presentation, and it's also will be made available on the Greater KW Chamber website. I'd like to now invite Graham Bennett. He's a partner with Learners LLP to introduce his colleagues, Alicia and George. Over to you, Graham.
Thanks, Ian. Learners is proud to be this month's presenting sponsor of the Business Success Series. I work from Learners Kitchener office, and I have the privilege of introducing today's speakers. Alicia Christian is Chief Privacy Officer at Learners LLP. Her privacy practice focuses on advising businesses and other organizations on privacy and information management issues, including privacy policies, developing training programs, conducting privacy impact assessments, and managing breaches. Alicia is certified by the International Association of Privacy Professionals as a Certified Information Privacy Professional Canada. Her non-privacy practice is focused on plaintiff personal injury. George Hamzo's practice is devoted to labor and employment matters. His work involves both advisory and advocacy services, where he represents both employees and employers. His advocacy work includes employment standards, wrongful dismissal, and human rights disputes, and he's appeared at various levels of court in Ontario and represented his clients in front of numerous tribunals. Please join me in welcoming Alicia and George.
Well, thank you very much for that introduction there. I really appreciate it, and I know Alicia and I are really happy to be here today. So I thought we might as well just sort of dive right in here. As you know, my name is George. I'm an employment lawyer with Learners. I'm here to talk about employment law in the age of COVID. What I'm going to be talking about today, I want to talk about briefly some amendments that were made to the Employment Standards Act that were meant to sort of help businesses deal with certain shutdowns that have been initiated by the provincial government. So just before I dive into it, I just want to make you aware, as you probably know, in Ontario, there are sort of two ways that you can be regulated if you're an employer. One is if you're provincially regulated. The other is if you're federally regulated. And so you'll see there on this slide, the Employment Standards Act will apply to those employers who are provincially regulated, and the Canada Labour Code will apply to those employers who are federally regulated. Just because of time here, I'll be addressing the Employment Standards Act. I won't have too much time to address the amendments to the Canada Labour Code, though if that's something that you're interested in, I'd be happy to touch upon it during the question period. Okay, so if we could go to the next slide here. Okay, so essentially last year when COVID hit and all the shutdowns started to occur, the provincial government enacted some changes to the Employment Standards Act to try and deal with it and sort of give some relief to both employers and employees. So you may have heard of what's called the Infectious Disease Emergency Leave. Okay, the Infectious Disease Emergency Leave is a provision, a leave of absence under the Employment Standards Act, which basically says that an employer can reduce hours or wages of an employee without having to lay them off and without terminating their employment. So, as you may know, under the Employment Standards Act, if an employer needs to temporarily lay off an employee, they can only do so for a certain period of time. So under the ESA, the Employment Standards Act, you're permitted under certain circumstances to lay off an employee for 13 weeks in any 20-week period, or a longer period of 35 weeks in any 52-week period. And the issue we were running into, if you recall last year, was around May or June. That 13-week period for the layoff was about to expire. And the problem with that is that if it had expired, right, it sort of triggers an automatic dismissal of employees, which would then mean that that employee is entitled to notice and or severance upon the termination of their employment. So the provincial government wanted to avoid all this, and the solution they come up with, it's a bit of a novel solution, was to basically deem certain employees to be on a leave of absence, and in doing so, it would avoid having to lay them off, which would avoid the expiry of the 13-week or the 35-week period that I just mentioned. Okay. So next slide, please. So there are certain conditions for the leave that I just want to point out for you. They don't apply in all situations. Of course, you're always going to want to seek out legal advice if you're going to implement these sorts of things. But I can sort of point you towards some sort of general principles here. So it's important to know that leave doesn't apply to unionized employees. Okay, so if you have a union at your workplace, then you're going to need to work with the union to try and come up with a solution, because these deemed leave of absence won't necessarily apply here. Okay, the reason for reducing the hours and wages of an employee have to be related to COVID. Okay, so that seems obvious, but it's important to emphasize here. You can't do it for other reasons. It has to be related to the COVID-19 pandemic, either because of government shutdowns, or if it was your business was directly hit by COVID, in the sense of that maybe there's some positive tests in the workplace. It applies retroactively to March 1st, 2020. I should note that there is a time limit on this. Initially, it was set to expire in September of 2020. That was pushed by the provincial government to January of 2021. That was again pushed. Right now, it's set to expire on July 3rd, 2021. Right. So if you otherwise qualify to put your employees on this leave, then you can do so until July 3rd, 2021. Now, there's a big caveat here, and it's mentioned on the slide at the bottom right-hand corner here. It says, it's unclear whether or not these amendments apply to both the common law and the Employment Standards Act, or just the Employment Standards Act. Okay. So what does that mean? Well, as you may know, in Ontario, an employer's obligations to an employee comes from one of two sources. One is what's called the Employment Standards Act, which is what I've been talking about, which is just a piece of legislation. The other is called the common law, or judge-made law. This comes from legal precedent and legal decisions. And so the two aren't always the same, but they're sort of overlapping obligations. Okay, so you may have heard of the term reasonable notice upon termination. If you terminate an employee without cause, they're entitled presumptively to reasonable notice upon termination. That's a common law right that an employee has. Okay, so why is this important? Well, it's important because it's not yet clear whether these amendments that I've been talking about, this infectious disease emergency leave, whether that just applies to the ESA, or whether it applies to both the ESA and the common law. Okay, so we could be left in a very odd situation where the court interprets these changes and these provisions to mean that they only apply to the ESA, but they do not apply to the common law, which would mean that you could have an employee, as strange as it sounds, on a deemed leave of absence under the Employment Standards Act, but in effect, because that person has been laid off, maybe beyond what the ESA dictates, that person could then be considered dismissed and entitled to reasonable notice at that time. Obviously, this is a big issue. The fact of the matter is, right now, employment lawyers we don't know how the court's going to come down on this. I'm not aware of any cases yet that sort of interpreted these provisions and made a decision on it. So it's something to keep an eye on. Practically speaking, what does that mean for you? Well, as I say, anytime that you're going to lay off an employee or try to put them on this leave of absence, obviously you want to seek out professional advice, preferably from a lawyer. But one thing you're going to want to think about is, the risk that these provisions will only apply to the ESA. And one way to mitigate against this, and again, something you should discuss with your professional advisors, is getting an employee's consent, securing their consent. Okay, so that's a really important distinction we have to make there. Okay, next slide, please. So, and I think this will be the last point that I have, just because of time constraints here, but I just want to address very, very quickly the infectious disease emergency leave does not only apply when it's initiated by an employer, but it also applies when an employee needs to take time off for certain specified reasons under the Employment Standards Act. Okay, so if an employee needs to take a leave of absence, an unpaid leave of absence, the infectious disease emergency leave under the ESA permits them to do so and essentially an employer can't punish them for taking this leave. You can think of it like a pregnancy leave or parental leave that's protected by statute, and as such there are certain prohibitions on reprisal under the Employment Standards Act. Okay, so what are some of the reasons that an employee could take this job protected leave under the Employment Standards Act? Well, they could be under medical investigation or supervision for COVID-19. Maybe they're acting in accordance with a government order, right? Maybe their physician has told them to stay home because of certain health risks that they may have, right? So there are a whole number of reasons why an employee can claim a certain leave or can claim the infectious disease emergency leave under the Employment Standards Act. This is not an exhaustive list, so you should always either consult the legislation or, again, your professional advisors when you're wondering whether or not an employee is entitled to that leave. Okay, next slide, please. Okay, so this is I think my final point before I pass it over to Alicia, but just in regards to the infectious disease emergency leave, there are certain conditions that apply. So first of all, there's no specified limit on the number of days an employee can be on the leave, okay? And they can also apply to part days, okay? And there are prohibitions on information that an employer can request to verify the eligibility of the employee taking that leave, okay? So the biggest one is that the legislation says that an employer cannot request a medical note, okay? What can you request? It's a good question. An employer can request evidence that is reasonable in the circumstances at a time that is reasonable in the circumstances. So what's reasonable in the circumstances, is going to obviously depend on the situation. Okay, so So one example I like to give is that if an employee says they have to stay home because maybe childcare center has been unexpectedly shut down, and that employee needs to then care for their children, right? Obviously you wouldn't request a medical note in that situation anyway, but you might want to request maybe an email from the childcare provider to just verify that that person needs to take that leave, or that that their childcare has been shut down, and in fact they do need to be home with their children. So I do have a whole lot of other information in these slides, but perhaps I can sort of tease out that information during the question period. But with that, I think I'll send it over to Alicia to talk about privacy.
Okay. Thank you very much, George. I'm just going to advance the slides. And okay, so as George and Graham have both mentioned, my area of practice is in privacy. So one of the things that has happened as businesses have had to adjust to the pandemic is many are now reliant on video conferencing in order to provide service to their clients. So last March, so 2020, I reviewed the Zoom privacy policy, as that's a pretty popular platform, and it was last updated in August 2020. And the information that's being collected by that platform, and it's quite likely that the others are collecting the same amount of data, is with the information commonly used to identify the user, such as their name, physical address, email address, phone numbers, and other similar identifiers, the person's job, such as title and employer, payment information, your Facebook profile information, if that's how you have logged into Zoom, general information about the user's device, network, and internet connection, including the type of operating system that you use, as well as information that's uploaded, provided, or created while you're using the service. So an extraordinary amount of information is being collected by Zoom. Before you use such a platform, you want to review the privacy policy to see what personal information is being collected from you and from your clients. You want to make sure that that the use of a video conference platform is actually permitted under your own business's privacy policy. It may need to be revised to account for the adoption of video conferencing by your business if that's not currently covered off in the policy. Before using a video conferencing platform with a client, make sure that you have their consent to do so, advising that the platform may collect some of their personal information of which you have no control. It's easy to confirm their consent by sending a quick email. You could have them sign a form as well to confirm that you have their consent to use that platform. Security breaches are possible through these platforms. I'm sure we've all heard about the Zoom bombing that was occurring at the beginning of the pandemic. So they do seem to have gotten that under control a bit better now. But your client's personal information could still be at risk by using these platforms. And having your client's consent is especially important if you're discussing sensitive personal information, such as financial or health information. You want to be able to advise your client if any of their personal information is stored by the platform outside of Canada, as it could be subject to disclosure pursuant to the privacy laws of that jurisdiction. And in terms of recording meetings, you should make sure that you have the participants' consent to do so. And also turn your mind to where the recording is being saved. Is it local to your own network or to your computer? Or is it being recorded to the platform's cloud? If in the provider's cloud, again, it may be stored outside of Canada, so there becomes jurisdictional issues with disclosure, and it may be stored in contravention of your own internal privacy policy if it's stored by the platform. With a slowdown in the number of people being able to go into brick and mortar stores, and it sounds like there's going to be another slowdown by the end of today, many businesses have turned to offering their services or products online. Doing so means that you will likely be relying on new software to allow you to adapt your business into the online or virtual realm. And before you do go online, there's a couple of things to keep in mind. It's advisable to conduct a privacy impact assessment before implementing new software or providing a service or product online when personal information will be collected, used, or disclosed. So a privacy impact assessment is a risk management tool that's used to identify actual or potential effects that a proposed information system or software or any other activity may have on an individual's privacy. It also helps to ensure that the program complies with the applicable privacy legislation. Most of you attending today, the privacy legislation with which you would be needing to comply is the Personal Information Protection and Electronic Documents Act. That's the federal privacy legislation. The privacy legislation does not actually require that a privacy impact assessment be performed. However, they are recognized as best practice in Ontario and quite frankly in Canada and globally. And then the next topic that I want to touch on is the outsourcing of data processing to third parties, which has become prevalent and it's really to be expected in today's data-driven economy. For example, if you have adopted an online shopping platform onto your website, you're likely relying on a third party to process your client's credit card payments. Businesses are not able to offload their privacy protection obligations onto these third parties that they're using to process their clients' information. When a business retains a third party, it's still responsible for ensuring that the information is properly protected and privacy legislation is being complied with. So when you're selecting one of these third-party service providers, you want to consider the following. Is there an appropriate privacy management framework in place with that provider? So you'd want to make sure that it's in compliance with PIPEDA, or the privacy legislation for Canada principles. Are there industry accepted security standards in place? Are there restrictions on the use of data by that third party, including who can access it? So you want to make sure that you're not giving your client's information to this third party and then they're using it for their own purposes. You want to know where that third party is storing your client's personal information. You really want to make sure that it's not being stored in a jurisdiction where there aren't good or adequate privacy legislation. You want to know how long that third party will retain your data. And you also want to make sure that you know who's responsible for notification if there is a security breach. So you don't want an unknown third party reaching out to your clients if there were a security breach. You would obviously want to be the one giving them that information to maintain trust in your relationship with your clients. The more sensitive the personal information that you're sharing with the third party, the more important it is to ensure that they have appropriate information protection protocols and security safeguards in place, and that those protections and safeguards are confirmed in a data sharing agreement. Oftentimes you'll get these agreements from that third-party provider. You have the right to negotiate in terms of the terms that are in that contract. So don't feel like you get this contract and you have no choice but to sign it. Give it to your lawyer to take a look at and see if they have any concerns, and then go to that third-party provider and tell them, I have some concerns about these specific clauses, so that you can negotiate the contract to provide the protections that you want to have in place. One other issue to keep in mind is cybersecurity. Audits, you want to know if there's any vulnerabilities in your network so that they can be fixed before the person trying to break in is a nefarious party. You can have your own internal IT department do that, a penetration test. And if you don't have an IT department, there are external cybersecurity companies that can do that testing for you. And you also want to look at your insurance policy if you have now started to provide virtual or online services to your clients. You want to make sure that you have appropriate coverage in place to protect that personal information of your clients. The amount of coverage that you will need will really depend on the sensitivity of the personal information that you're collecting, using, and disclosing. There's often additional cybersecurity riders that you can purchase to supplement your standard coverage under your commercial general liability policy. So some things that you would want to discuss with your insurance broker is whether you currently have first and third party coverage for data breach incidents. Does your insurance company provide you with access to lawyers, crisis management teams, or forensic IT firms if there is a data breach? What kind of coverage do you have if there is a data ransom payment that's required? Are regulatory fines included in your coverage? And then finally, do you have business interruption coverage? So if your data were held ransom and you no longer have your access to your data and your business is down for a few days, will your insurance provide coverage for your loss of income for those few days that you weren't able to be in operation? Privacy litigation, especially class actions in response to data breaches, are becoming more prevalent. So you want to make sure that your business has appropriate insurance in place to cover losses from a breach. Here we go. So I think it's now time for our fireside chat.
There I go. Wanted to make sure I was back on there. Well, thank you to both you and Alicia and George. And I'm going to go a little off script, just that I know it's topical. I've already talked about it several times already today, and we haven't even had the Premier make his announcement. But the whole question of the sick leave, programs, and I wonder if you want to comment, either of you, on, there's a federal program, and there's now some discussion. What should the province do about having sick days so that people that are ill can stay at home and still be paid? Maybe from an advisor to a business, what would your advice be to businesses around this? Because you've got responsibilities for under labor law, etc. In terms of sick leave and having your employees do what they need to do to stay safe and to protect your workplace, any thoughts on that? We're advocating that that certainly they get it, or they have discussions and stop pointing fingers, because really ultimately businesses just need some clarity around how they're going to pay for it. And for most small businesses, it's just one more expense that they may not be able to afford. So between the province and the feds, what would be your advice or your thoughts around sick leave for employees?
Well, I guess I'll jump in there. So if you can do it, if you can implement some sort of benefit plan for your employees to do that sort of thing, I mean, that's good on you. That's great. I just don't think realistically that many businesses can do that, right? From an employment perspective, the way I would look at that is that I think with these upcoming shutdowns, it's inevitable for many businesses, unfortunately, right, that you're going to have to implement something like, these infectious disease emergency leave, or you're going to have to take advantage of it, right? And under those provisions, from an employee's perspective, right, as long as those apply, and I'll insert the caveats that I had mentioned during my presentation. As long as those apply, right? I mean, it's an unpaid leave. You're not mandated to, under the infectious disease emergency leave, to provide your employees with compensation during that time. From my perspective, if I'm sort of thinking protecting businesses, protecting an employer, as I say, getting the consent of the employees is important if you're going to be implementing, a long string of layoffs, or if you're going to be using this infectious disease emergency leave. Because I can tell you that initially, I think employees were on board to a large extent with some of these layoffs and leaves of absence. Global pandemic, sort of act of God sort of thing, right? I mean, I think employees were sympathetic, but the longer it goes on, right, the less sympathetic the employees are going to be to the plight of the employer, and I think the more likely they're going to try and challenge those sorts of things. So if you can, obviously you'll want to talk to your professional advisors, but if you can secure consent of the employees up front, right? If moving into these new shutdowns that you think you're going to have to take advantage of this leave, getting the employee consent so that 3-4 months down the road, when the employee comes back to you and says, hey, I'm not happy with the situation anymore, at least you'll have something to rely on in terms of securing their consent. So long-winded answer, Ian, but I hope that.
But you know what? This is the issue, the complexity of what's happening with COVID. There isn't easy answers, and we got to ask these questions because the vast majority of businesses across the country, and that your clients, our members, are going to be that small and medium-sized business, and they're asking these questions because they're running on fumes in terms of if you have been shut down, and there's a chunk that are doing well, but the vast majority have been and impacted in some way, and some very severely, and want to keep their employees connected. But they got to do it in a responsible way, but also one that is financially secure. So appreciate you kind of bringing that to light. Alicia, one of the things that has come out from either the municipal or the provincial orders is businesses requiring screening of their employees for COVID-19. We've all been through that checklist, right? Have you been out of the country? Well, no one's been out of the city, maybe not out of their house. So, but there's a whole list of questions. Do you have the sniffles, fever, etc.? What's the obligation to be done with that information? Is to have it and hold it in case there's, for contact tracing? What's the responsibility? Because I actually have people asking that all the time. You do these screenings. What are you supposed to do with the information? What's your responsibility as an employer to do with that information?
Yeah, so the mandate came from the provincial government to do the screening of your employees, and it's also of essential visitors to your workplace. So that would include like delivery people, so Purolator, you would want to make sure that you're having them screened as well. In terms of what your obligations are to the employee, you need to be informing them why you're collecting it. Obviously, it's to comply with the legislation and also to maintain a safe workplace. So you also need to be letting them know how long you're going to be retaining that information and who it's going to be disclosed with. So you should not be disclosing the information to anyone other than your local health unit. If you get contacted because there was some exposure or potential exposure in your workplace. When you store the information, so you can either, there's really one of two options. There are electronic like apps that you can rely on to have the screening information collected, or you can just have a questionnaire completed when the employee comes to work. It needs to be administered before they enter the workplace or right at the entrance. And then that information, you want to store it in a secure location. So their forms or the questionnaires do not go into their employee file or their personnel file. It needs to be stored separately, and it should be stored securely. So in a locked file cabinet, because it is considered personal health information. You are only permitted under privacy legislation to retain information for as long as it's needed for the purpose for which you collected it. So in this case, really primarily it's for contact tracing. According to the medical literature, it's about a 14-day period where you could, contract COVID after being exposed. So I would recommend at most storing it for 30 days. After 30 days, it's really of no use for the purpose for which you've collected it, and then toss it in the shredder or delete it from the network, depending on whether you're doing it electronically or in hard copy.
You know what? That's good. That's good information to have. I actually didn't know the answer to that question, so it was good that it came up in our conversation. So it is a response. You don't do anything with it unless you're asked from it by a public health unit or a government agency that would have rights and ability to ask for that information. If it's not needed after, say, 30 days, and that's probably a good window of time, is that it's then your responsibility as a business owner to safely dispose of that information because you're not required to keep it anymore and frankly shouldn't have it. So that's important because our office is closed, so we haven't had to do that, but I know in other parts of a basketball association, other organizations that still occasionally have people, It wasn't clear to me what you're supposed to do with that. That's very helpful. George, or maybe I'm going to stick with Alicia. If you're still having employees come to work, or for that matter, have a diagnosis of COVID-19, whether they're in-person work or at home, this has come up as well, and I think it's becoming clear, but I thought we should reiterate that. What's your responsibility to inform the rest of your staff, especially if you're in the workplace? What's your responsibility to either notify staff, or do you have an ability legally to inform other staff around that diagnosis? Because you get into privacy, and then you also get into labor law about saying what's your responsibility to the rest of the employees. Walk us through what that looks like.
Right. So if you find out that one of your employees has contracted COVID and they have not been in the workplace, so they're at home, and they need to take a leave to deal with, their symptoms and recovery. In a case like that, you absolutely would not advise anybody else in the company, because there's no risk of exposure to the other employees. Now, if the person is attending at the office with co-workers and there's potential for exposure, then how much, it's a total lawyer answer. It really depends, because you need to make sure that you are protecting the privacy of the individual who's affected, but you have to balance that as well with your obligation to provide a safe workplace to the other employees. And when you have a small business, if you only have a handful of people in the office, you say, oh, you've been exposed, and then somebody's not there for 2 weeks, you can kind of figure out who it is. At the same time, you do want to make sure that your other employees are taking appropriate steps, not only because if you don't, you run the risk of your patrons then becoming infected if your employees were exposed, don't get tested, and now we've got an outbreak. So you are able to notify employees who have had close contact with the affected person to self-isolate. And then those who may have been in the workplace but say we're in a different section of the building, so their chance of actually having been exposed to the affected individual, you can tell them to self-monitor, and then not give any further information about who it was that they came in contact with that exposed them. Obviously, if you get asked about that, you would just need to say that due to your privacy obligations, you're not able to provide any further information other than to let them know that they had been exposed. And if it's a high exposure, then self-isolate. And if it's a lower risk, then to just self-monitor.
Okay, that's helpful. George, a couple of questions around, can an employer, for any number of different reasons, require or request, I guess, at least ask for a medical note for an employee who's taking time off for reasons related to COVID? And that could be, again, self-isolating. It could be they got a diagnosis or they had a screening that indicated they may have been exposed. Can you seek a medical note, and why would you need one as an employer? I mean, I guess that's one of the questions is, do your employee benefits providers require one? So walk us through that part of it. What should you seek from an employee who has had some sort of a diagnosis or is off related to COVID?
Good. Okay. So, I mean, why an employer might want that information, I think, is probably to discourage abuse. I think what we were seeing, especially in my own practice, was a lot of employers who were not very happy with employees basically saying, oh, I've got the sniffles, I've got to stay home for 2 weeks and collect CERB, sort of thing, right? So there was an impetus, I think, from employers to sort of discourage that kind of behavior. And so I think that's why employers would want it. The provincial government, though, I think through the infectious disease emergency leave provisions under the Employment Standards Act, have made it fairly clear that if an employee is requesting to take that leave, then you are not entitled to a medical note, and you should not ask for one. Potential problems of you asking for one are that, you'd be in breach of the Employment Standards Act. It could be considered a reprisal under the Employment Standards Act if you do ask for one in those circumstances. So you should avoid it. As I mentioned in the presentation, an employer can request reasonable evidence, or evidence that's reasonable in the circumstances at a time that is reasonable in the circumstances. And I'm just going to have to say what Alicia said. It really depends on the circumstances. What is reasonable in the circumstances, because the legislation does not really help us out all that much in terms of delineating, here's, this is reasonable, this is not reasonable. Okay, so really have to be prudent. If you really have a tough time with something, I think, contacting your lawyer, running it by them and seeing what they have to say about the situation. But again, some examples might include, I'm hearing rumblings right now that they might close some schools, right? I mean, that's inevitably going to put pressure on those, the families of those children, right, who might not be able to, come into work, while the schools are shut down. So that would be, as far as I can see, a legitimate reason to take it. And if that information is widely known that the schools in your area are going to be shut down, then I'd probably say in that circumstance, it's not a whole lot of other information that you might need as an employer, in terms of verifying eligibility for the leave. Now, sorry,
Okay.
Go ahead, Ian. Yeah.
No, I was going to say late breaking news or early breaking news is Waterloo Region is not shutting its schools because the province is leaving that up to the public health units. So the ones that have been announced, Guelph, Wellington, Toronto, Peel, York, maybe, the ones that have been announced, but it may happen, but that's going to be up to the public health unit. So I just was looking at, I got that email before we went on. So if you can't, sorry, go ahead.
So I was going to add, part of what the government required was that business have a COVID return to work policy. So one of the things that you might want to include to try to prevent abuse would be to have, maybe, in terms of the reasonableness, if this is your third request for time away due to COVID symptoms, you will need to provide a doctor's note at that time. So you're essentially kind of balancing the collection of personal information. You've already given 2 opportunities, but again, speak to your lawyer and get.
I think this is a labor, how you manage your own workforce, regardless of COVID. This can be an issue in certain circumstances, and so it's always a bit of a struggle. To follow on to that, if you can't request a medical note, or at least it needs to be, as you've just described, Alicia, maybe a third occurrence, and you're trying to manage that, what can you request, or what are the tools that you might have available? I mean, it may be, please check in every morning with your supervisor. Let us know how you're doing. What can we do to help to get you back? I mean, is it those sorts of things where leaving someone unattended? We know that literature would say the longer they're out, not in the workplace and not doing their job, and you're not talking to them, the more likely the longer they're going to be off. So is it those types of things, or is there something else you can request to kind of make sure that you're managing your human capital, which is the most important thing for any business?
Yeah, it's a great question. I'm not sure there's a straightforward answer, unfortunately. I think that, it will depend. So for example, right, if somebody says I've gotten a positive test for COVID, well, we know, obviously I'm not a doctor, but we know pretty well that, it takes however long for that to go through your system until you no longer have symptoms, and you can no longer give it to anybody else, right? So I would expect in that situation where the employee is saying that's the reason I'm off, in that situation, 2 weeks, 3 weeks, right? Would be a reasonable amount of time that employee has to take away from the workplace, right? Whereas somebody who's got a late call from a child care center and they say, well, your kid has a fever, right? Come pick them up, right? Also, go get a COVID test, right? And you're not coming back until such time as your kid, has a negative test, right? And so in that situation, it could depend on, the child of the employee, whether they test positive or negative, right? If they test negative, then really, a couple of days maybe, right? For something like that. Obviously, you want to be careful. You're not entitled to the medical information of that child. But if the employee is offering up that information and saying, this is the reason why I cannot attend at work, right? I think, you can base your decision on, the information you have in that regard. So the government intention, and whether this is good or not, the government sort of intentionally left this kind of very broad in language and scope, right? So that, what they want to avoid, it seems, what they're trying to avoid, I don't know how well they're doing, but what they're trying to avoid are terminations, right? They're trying to avoid mass terminations, right? What they want to say is, it's okay if they're not working or collecting a paycheck at some point, right? But what the provincial government is trying to avoid are sort of broad scale terminations, right? People losing their jobs. So that's the way they've chosen to do it. And as I say, I'm sort of agnostic as to whether or not this is the best way to go about it.
I think what we get from this is, and I love lawyers, but there's nothing ever easy and there's no clear answers usually when it comes to legal matters, but especially with COVID. I mean, we're all, this is not something that frankly, many courts or others have worked with of this type of pandemic before. So it's not easy to get the answers. Listen, there's a couple of questions that came in the chat box which follow on to another question I had. And I'm going to start maybe with George, and it relates to we just announced a rapid screening pilot for small business. That they can get access to free rapid screening, the Abbott tests, which are the Cambridge Chamber and ourselves, and Communitech's doing another portion of that for really small businesses and individuals. Those screenings are free. We're making them available so someone can take those or pick those up at the Cambridge Chamber of Commerce, take them into their workplace. People can self-administer them. That's allowable now by the province. And so it has to be at the employee has to agree to it. You can't force them to do the screening. And then there's a reporting, which we hope the information can at least get reported to public health that you've had the test and what your result was. So I guess the question comes, and it really is, it falls on with vaccines, because one of the questions is, can you make vaccines compulsory to be in your workplace, right? And that's, I'm sure you're going to give me a not easy answer, but that's a question that many businesses have. Say, I want everyone that's working in my workplace to have a vaccine because I know I can be safer. Then you've got this issue around when you're doing screening or testing. You can't compel someone, but how would you do that in a permissible way to make it available to staff that they could do that before they start their shift, as an example? And then I guess the third piece is, there's this question, and it's probably more prevalent in the States right now, is, oh, I've had my vaccine, therefore I don't have to wear masks. We do still have a regional bylaw that for face coverings. We're hoping that people wear those surgical masks to really contain the spread. So all of those things are sort of together. How do we approach that as employers? You want to do rapid screening so you can identify who's sick and make sure that they get the help they need and they're not in your workplace. Vaccines, we know, are the real answer to get back to a new normal. And then what do we do with the public health guidance around about PPE? So there's one question with 3 parts that'll probably take the rest of our time, but I thought I would roll that together because I think they're pretty important. Who wants to go first? George, you want to take a crack, and then Alicia,
sure. I'll try my best there. So, I mean, you know, I'm glad you said you anticipated the lawyer answer, Ian, so I'll have to give it. But, you know, with the vaccinations, I mean, look, you know, there's not a lot of clarity on this, okay? And what I would say is, you know, from my perspective, until the provincial government intervenes and says, you know, you can, or maybe these industries, you can force vaccinations. I mean, I doubt it. I don't think a court would uphold that. But again, that is by far a sort of settled opinion in the area. That's just is sort of my initial thoughts on it. I doubt the court would do that. Maybe there are certain industries, right? When we're talking about if you're working in a long-term care home, or if you're, you know, I'm fairly certain if you work in a child care center, I think you do have to get certain vaccinations. You know, you have to prove that you've had certain vaccinations. So maybe it'd be easier to push it through in certain industries, but I doubt that you'd be able to force your employees to do so. So maybe I hope, as I said, I think we'll learn more, Ian, as the court inevitably is going to have to deal with it.
But you know what, George? The answer is the answer, right? Which is there isn't clarity, but people are asking those questions, right? Businesses are asking those questions. Alicia, any other thoughts on and even if it's not clear, what should an employer be doing to try and, because part of this is a vaccine hesitancy. Part of it is saying, in order to keep this safe, what are the things we're going to do? Are there things like saying, no, you don't have to have a vaccination, but unless you can demonstrate that you do, you'll be working in some modified way. Like I won't have you in the workplace because that puts others. I mean, I guess those would be the types of questions that businesses are asking related to, again, rapid screening, vaccinations, all of those types of things as we sort of get to that part of this pandemic.
Yeah. And even having something like making them work in a segregated area if you're not vaccinated is really a breach of privacy, because you've now told everybody else in your company that these people don't have a vaccine. So you need to be really mindful of how you're going to go about asking for vaccination. You would want to, if you were going to try and make vaccines mandatory, and I agree with George, there's certainly no statutory authority to do it. You'd really be having to rely on your statutory duty to provide a safe workplace. And that's really going to become industry specific, as George mentioned, like going into an office versus going into working with vulnerable people. There's a difference in terms of the precautions that you need to take there. If you were going to ask for, just confirmation that the vaccine, that you'd had the vaccine, you need to be explaining, you have to provide an employee with the purpose for why you're collecting that information. You need to do it in the least privacy intrusive way, so to show it, and that's the end of it. You could record it, but that's not the least intrusive way. Now you have a record of their personal health information, and you would want to destroy that information once it's no longer useful for the purpose. And the other thing too that you need to keep in mind, and be mindful of all of your COVID practices that you have in place, is that you need to be looking at what's going on in the community. Like obviously right now the numbers are very high, you want to make sure you have a lot of precautions in place. But as more people get vaccinated, our numbers are coming down, we're getting to a point where there's herd immunity in the community, then do you still need to be asking for their personal health information in terms of vaccinations and test results and things like that? Because once it's safer in the community, it's assumably safer in your workplace as well, and there's no longer that need to be getting very sensitive personal health information from your employees.
Okay, and I think that answers, there was a question that came in around, can you require employees to get a COVID test? I think the answer to that is no. That's a public health issue, but and the other is, and I think you've answered this, is it can't be prescriptive on some of these things, whether it's vaccines or screening, but you can try and incent. One of the suggestions is, could you bonus people if they demonstrate that? I presume you can try anything to try and incent people in your employee to do something that you'd like to do.
Absolutely, and even when we have more vaccine and there's greater vaccination of the essential populations, I'm sure there's going to be either the health unit or private companies that you can have come to your workplace and administer vaccination. And so that would be a very easy way to get your staff vaccinated. Obviously, it's not compulsory, but when you literally, you're already coming to work for that day and the health unit's going to be there to give you the vaccine, make it extremely convenient for your employees. There's also, the peer pressure of all, oh God, all my colleagues are getting it done, I better get it done too, right? So that's an easy way to, get your staff vaccinated, just make it very, very easy for them. Or like you said, provide incentives to, you get half a day off of work to go and get your vaccine, that type of thing.
And that's part of the reason of this rapid screening program we just announced is we want those to go right, the employer to take it right into the workplace, self-administer where it can be done, and you're going to have probably greater uptake on that. Listen, we have 4 minutes and we have 3 questions left, so I'm going to ask you to give very succinct lawyer answers to this, and I'm going to wrap two together for George. Really simple question here, George. You talked about layoffs in the presentation, the importance of the written contract and deemed leave of absences under the Employment Standards Act, and needing to make sure that you avoid automatic dismissal with the layoff provisions. Maybe talk just a little bit about that, the importance of that. And if things do change, is there a way to impose new, well, I guess, contract or new provisions of your, the elements of your employment, given that we know things have changed in many workplaces. Many job functions have fundamentally changed and are never going to go back. Maybe I'll give you 90 seconds to try and answer both of those questions, and then we can always come back and answer that in the future.
Okay, so I'll do my best. So there are ways to impose new terms of employment on your employee. So when I mentioned that in the slide, what I was getting at is that this infectious disease emergency leave is going to end at some point, and it's probably likely that your business is not 100% at that point, right? And so you still may have a need after this sort of grace period expires to lay off an employee. It's important to know you only have a right to a layoff, to impose a layoff, if it's in your contract. Okay, so a lot of employers will assume that they have a standing right to lay off an employee, and that's just not true. So it has to be in an employment contract. So it's sort of a new age. A layoff provision is not something that you would usually put in an employment contract, but because of COVID, what's happened is more and more businesses need it. That we're not just talking about the construction industry, right, where work is kind of ebbs and flows, right, but we're talking now about most industries where you may need to impose a layoff, and the way to do that is to have a contractual right to do so. If you don't have a contractual right to do so, you'll need to impose a new contract on the employee. That's tricky business. One of 2 ways to do it: either you provide reasonable notice of the change, or 2, you provide fresh consideration, meaning some sort of incentive for them to agree to the new terms of employment, usually in the form of some kind of signing bonus. Okay, so I hope that answers your question.
Very impressive that you got that all into 90 seconds. Way to go, George. Okay, last question to you, Alicia. And I've had this question. A number of us in the business community have had this. Is the region of Waterloo and many public health units would say there's an outbreak in a certain workplace. I think the definition people would be surprised to know is there's more than one case in that workplace. Once you hit 2, you're into an outbreak. I know a little bit about this because my parents live in a retirement community, so we get updates on that. And it took a while to understand that once you hit 2 cases in a workplace, no matter how many employees, you're deemed to be in an outbreak. Maybe talk a little bit about that, because I think it's a concern to a business that if you have 2 employees who may have contracted it, you're going to be outed as being a workplace that has an outbreak. And I think just in the last minute or so we have explained that, and maybe give some comfort to business about what they should do.
Yeah, so in terms of the health unit actually reporting those outbreaks, the region of Waterloo, actually, I think it was March 17th or 19th, your health unit indicated that they are going to start releasing the names of workplaces and facilities where outbreaks that reach certain criteria will be announced with the actual name of the workplace or facility. Those criteria are that there are 15 or more cases with 15% positivity and at least 20 employees or patrons in the workplace, or there's 50 or more cases. As well, there needs to be sustained transmission in the workplace, and there needs to be no significant privacy concerns. So for your name to get released, you have to actually hit those criteria. They can announce that there's an outbreak. They are reported by sector, unless you're hitting those criteria. The one thing to keep in mind is that they need to be mindful of privacy obligations. So if you have a very small business, and they would need to consider whether or not they can actually release your name, and if that would end up disclosing the people who have been infected. Mind you, if they have to weigh protecting privacy versus protecting public safety and health, then they may choose to err on the side of health and safety.
All a good reason to make sure you're doing screening and keeping people safe so you don't have to deal with that. But that's a helpful explanation. Listen, we're out of time. You guys did a fantastic job. Thank you so much. There's a lot of great information here. And as a reminder to folks, we'll be sending this to those that listened in, a copy or a link for this session. You can record it again or share with your colleagues. It'll be available on the Chamber website for those that didn't join us live, because there's lots of useful information here. That for every business, especially a small and medium-sized business. So big thank you to Alicia and George. Thanks for joining us today. It does bring us to the end of today's session. So a big thank you once again to our title sponsor for the series, Manulife, our platinum sponsor for the series, the Immigration Partnership of Waterloo Region. This month's presenting sponsor, our friends from Learners, LLP. Thank you so much. And now they're new neighbors of the Greater KW Chamber right beside our office in downtown Kitchener. If we ever open up again, we'll look forward to seeing you at the neighborhood block party. And to today's speakers, George and Alicia, we appreciate you joining us. Finally, to all of you for joining us today, as a reminder, we do host a new Business Success Series session every Wednesday at 1 p.m. Join us next week as I sit down with my good friend and colleague, Greg DeRocher of the Cambridge Chamber of Commerce, as we discuss operating your business safely during COVID-19. We'll talk about our chambercheck.ca program, where we will have, we've talked about it today, rapid screening tests available, ask the expert on the cash flow support programs to support business. We'll have something to say about masks, free masks for businesses, the surgical grade masks, and our Chamber Business Ready certification program that we do with Exonify. Lots of great information and tools for every small business, and we'll be discussing that with Greg next week. You can register online at greaterkwchamber.com. Please share this series with your friends and colleagues. Join us every Wednesday afternoon for another edition of the Greater KW Chamber's Business Success Series, because if it's Wednesday, it's the Business Success Series. Thanks so much and have a great afternoon.